Good morning and welcome to today's webinar, Employment Law Update, presented by our sponsor, Heffernan. We're super happy you can join us today. My name is Michelle Wilcox and I will be your moderator. I'll also be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we may discuss can be found at the URL currently showing on your screen. I'll be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio, your devices control the audio. So if you have audio difficulties, try adjusting the volume settings on your device. If a telephone line goes down during the call, hang up and call back again at the same number. If all lines go dead, watch the on-screen questions box for an alternative call-in number. Feel free to ask questions or provide feedback by using the questions box during the webinar. If you're using a tablet, you may need to tap on the screen for the options bar to appear, then you can select the appropriate option. We may not respond immediately, but we will work your questions and feedback into the presentation. If we can't get to your comment or question during the session, we'll be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions at the end. And lastly, we have a number of upcoming webinars covering a variety of topics, including those listed at the Heffernan webinar website. In addition, we are also offering the mandatory Preventing Sexual Harassment training on June 11th this year. With that, let's begin. Today, our presenter today is Lauren Bushman. Lauren is an attorney at Fisher Phillips, where she practices employment law. She represents companies in various areas of employment litigation, including when employees sue their employer for wrongful termination, harassment, discrimination, wage and hour violations. Lauren also counsels her clients on various employment matters, including employee terminations, employee handbook updates, and wage and hour issues. Lauren enjoys keeping her clients up to date on employment laws to mitigate litigation exposure. And with that, thank you for being with us today, Lauren. I'm going to go ahead and switch the presentation over to you.
Great. Thanks so much for having me, Michelle, and good morning, everybody. It's great to see so many people signed on and logged in on this nice Tuesday, well, West Coast morning, East Coast afternoon, I guess. We're straddling the noon hour here. So thank you all for joining us. Michelle was pinging me about getting these slides so that we could load them into the presentation this morning, and I kept having to say, 1 more minute, Michelle, 1 more minute, because we have so many updates for 2025, not only that we kind of knew about at the end of 2024, but also, obviously, it's been a very, I mean, not, I guess, obviously, but unless you've had your head in the sand for the last month or so, it's been a very busy, legal update platform under the new administration, too. So we're going to talk a little bit about what 2024 looks like, what we can bring into 2025 that we've learned from 2024, and then obviously some new administration updates and the whirlwind that's happening there. So none of what we talk about today is reflective of, you know, my views or the firm's views or anything political. It's, you know, we're just here to talk about updates, and we'll keep it as, you know, objective and applicable to employers and HR departments as possible. So I feel like I've been with you all a handful of times now, and I really enjoy this update, especially at the beginning of the year. And I almost changed the title. I think I've used this one a handful of times. So it's, you know, the year what now. It didn't fully capture the updates that we've got this year, but I couldn't think of anything better. So here we go. It's 2025. What now? I think what the heck is happening is maybe a better way to put it. But here's our outline for today of things that I want to chat with you all about. Like Michelle said, please feel free to drop questions in the chat. If I can get to them as we're going and there's a good pausing point, I'll happily respond to them. If not, I'm more than happy to email. If we have time at the end, we can chat or email with you back and forth.
Lauren, I don't mean to interrupt you, but it looks like you're not in the presentation mode. We can see your notes section.
Oh, so I'm sorry.
That's all right. I thought
Thank you for letting me know.
No problem. Again, I didn't mean to disturb you, but carry on.
Totally fine. How's this?
Perfect. All right,
Awesome.
great. Thank you.
Thanks, Michelle. Attorneys in technology, there's always, we're not, I won't pride myself on being the best at that. So thanks, Michelle. All right, so here's what we want to talk about today. We've got some state legislative trends, some things that we've talked about the last couple of years to check based on. The Trump admin, the first month, what the heck has been going on? It's been very, very, very active. Usually we talk about the first 100 days, right? I feel like we're talking about the first 20 days here. The federal minimum wage and overtime exemption is definitely worth a minute chatting about here. And then some EEOC trends. On these national updates, I'd like to look to the EEOC, the Equal Employment Opportunity Commission, to see at the national level what has been going on. And they've really been focusing on the Pregnant Workers Fairness Act and some AI updates. So I'd like to chat about both of those. Of course, we've got some OSHA updates since this is a national update. We've got a quick slide or two on the non-competition, non-compete agreement status. We've got the Chevron case, if we can get to it, which came down in June of 2024. I'm sure you've heard of it. I'm sure it's popped up on your newsfeed a couple times. And then just some solid California updates at the very end for everybody who's in California. And for people who aren't in California, California tends to be a little bit of a look ahead to see, potentially what will be happening at the federal level in the future. So let's jump to it. The state legislation trends we've got from 2024. It was a busy year. I feel like we're back from COVID, we're moving away from COVID legislation and those issues and that litigation. We're really moving into some new topics, including AI, mental health, employee initiatives, all of these. So there were over 76,000 bills introduced in the state legislatures across the country. There's a couple states listed here that had enacted the fewest bills. If you have employees or business in Alaska, Ohio, Missouri, North Carolina, or Pennsylvania, not all that active of a year for you, not all that many updates. Minnesota, Illinois, Ohio, Missouri, and New York put a lot of bills out there and only enacted less than 1% of those bills, so not very efficient. But on the other hand, Arkansas was super efficient, only put forth bills that they wanted to enact. So if you're asking yourself, what the heck are all those bills? Here's the main breakdown of topics that were included in those bills. There was a lot of AI talk. There was 45 states that had bills regarding artificial intelligence. There was a handful of inflation-related bills, mental health bills, which I mentioned, pertinent to employers, employees, workplaces, and not, and also electric vehicles. I feel like we've talked about this in years past. This is a cannabis, marijuana legality map. So just a quick update. We've got 4 categories here. One, the first, the darkest green being where it's legal for adult recreational use in those states. Probably no surprise in those. The second darkest green, testing my color skills here, where it's legal for medical use only in those states. The lime green, the lighter one, is where only low THC use is medically legal. So there's a little bit more of a fine line of differentiation. And then the orange states, there's actually no program at all for legal THC. So just a quick update on there. I feel like we usually get questions about that, about where the cannabis laws are standing state by state. And then this one's been interesting in the last couple of years. We've got a map of the paid leave laws by state. So whether it be paid sick leave, paid family leave, and or medical leave, or both, or none. So the majority of the states, as you can see, are the green color, and there's actually no paid leave laws required in those states. The purple is where there is paid sick leave only, and the blue is where, which I don't see any, oh, except for Delaware, tiny Delaware, where there's paid family and medical leave. Actually didn't know that, that was news to me. And where there's both in the orange, they have both paid sick leave and paid family medical leave. So if you're operating in one or multiple of these states, things may be changing keep your eye out for updates on paid sick leave and or paid family leave. All right, so let's jump into it. I gave a what to expect under the new administration update, I think the day before, or the Friday before, Thursday before the inauguration day. And a lot of what we were predicting, what we were expecting, has already actually happened under the new administration. We have a very unique position where we were able to pull information, from the first term under Trump's presidency and combine those with statements that he made on the campaign trail and things that the Biden administration did differently. And now we're kind of seeing that pendulum swing back to a more employer-friendly landscape. And the admin, as soon as it turned over, got very busy the first month. So what did we see? We saw an elimination of government DEI policies. And actually, this is what I was updating or reading about last night. Just yesterday, the day before, I think it was yesterday, there were 16 Democratic state attorney generals that issued a joint guidance reaffirming their position that workplace DEI, diversity, equity, and inclusion initiatives remain legal and important to the modern workplace. It was February 13th, that guidance was signed by the attorney generals from what you think of as the traditionally blue states, such as Massachusetts, Illinois, California, New York. They basically directly responded to the Trump administration's recent executive order and other actions taking aim at corporate DEI programs. I know it's been a topic at both publicly and privately traded companies in the last 20, 30 days. So good to probably check on DEI policies and where you are with those at this time. We're seeing, some responses, but that executive order is still out there. So make sure you're up to date on that. What else happened in the first couple days? The new admin directed civil rights agencies, including the Department of Labor, the DOL, and the EEOC, as we mentioned before, the Equal Employment Opportunity Commission, to recognize only two sexes, being male and female, when enforcing anti-discrimination laws. So definitely a rollback from what we saw previously. The new admin reversed the Biden era policies, including a measure to regulate artificial AI. From what we've read and I've been able to digest so far, Trump is wanting that to be less regulated and businesses to deal with it more on a business by business basis. There was a hiring freeze and federal workers were ordered back to the office. So we talk about this every year, but the states have increased minimum wage for year after year, quite some time, especially in California. Whatever states you have employees in, make a list, do a quick Google, make sure that you've got up-to-date information on any minimum wage increases that happened January 1st of this year. The federal minimum wage is still a little bit up in the air. Trump has been unclear about raising the federal minimum wage. He was opposed to increasing it in his first term and reasoning that it was harmful to small businesses. And he opposed an increase to it in the 2020 election. But then in his recent campaign, the website said that he actually supported raising the federal minimum wage. But the jump to $15 per hour is unlikely. That's a pretty big jump, right? So we're expecting him to revoke that Biden executive order setting forth the current federal contractor minimum wage. And again, that's only for federal contractors. So we'll see where that goes. But again, the raise in federal minimum wage may be irrelevant for some of you all with employees in states that have state minimum wages that are higher than federal minimum wage. But good thing to keep an eye on. It's probably why that because it's been left up to the states for quite some time and the states have gone over the federal minimum wage. That's why the federal minimum wage hasn't probably grown or been increased in the last couple of years, or a handful of years, actually many years. So just keep an eye on it. But then the thing that loops into this that I really wanted to talk about was the federal overtime rule. So in April 2024, the Department of Labor implemented a rule that raised the salary threshold for white collar exemptions from $44,000 on July 1st, and then it was set to kick up all the way to $59,000 on January 1 of this year. However, there was an immediate challenge in the Eastern District of Texas, and on November 15th last year, Judge Sean Jordan ruled that the Department of Labor actually exceeded its authority and said that the white collar exemption should be evaluated based on duties, not a salary test, especially a very large increase in the threshold for the exemption for the salary test. And we'll talk about this later, but the court also cited the Supreme Court of the US, the US Supreme Court opinion on Loper Bright Enterprises, which overturned that Chevron doctrine, which gave greater judicial discretion and interpretation, which enabled the court to strike down the agency's rules more easily. So this was one of the first times we saw that happen after the Chevron doctrine was overturned, which we'll talk about later. So if you were prepped and ready for that federal overtime exemption increase back in July last year, and then again at the beginning of this year, it didn't take place. It's currently on pause, and we have yet to see what the Trump admin will choose to do about that appeal and where that lands. But always a good reminder, even though it didn't go into effect, to at the beginning of every year or at the end of every year, whichever you'd like, good to go back and review both not only minimum wage, but also when you have workers classified as exempt, confirm which exemption they're fitting under and make sure they're meeting those minimum salary thresholds in both your state and at the federal level. Okay, so let's talk a little bit more about the EEOC and what's been going on. It's been an active EEOC year, which we don't anticipate will slow down anytime soon. We've seen a handful of charges filed. So there were, I think, over 80,000 charges filed with the EEOC, which was up 10% from 2022. Most of them we saw were for retaliation. So employees claiming that their employer retaliated against them for whatever reason. Usually it's protected speech or complaining about wages, raising what they believe to be a legal violation, and then some form of retaliation resulting, whether it's diminished wages, changed schedules, termination. So there were over 46,000 charges for retaliation filed with the EEOC. And then the rest, as far as categories go, the rest of the charges fell into a breakdown of about 36% discrimination, 34% race discrimination. Disability discrimination was the first category. Disability discrimination, race discrimination, sex discrimination was in the mid-30s. Religion was only 5%, which was a really dramatic decrease from 2022, probably because of the COVID-related things and the religious exemption that we were dealing with or looking at. And then age was about 17%, so lower. So in addition to the charges being filed, what did the EEOC actually file as far as lawsuits, right? They decided they were going to take it to the next level and not dismiss the charge and actually file lawsuits against the companies. So there were 110 lawsuits filed for the year ending September 30th, 2024. And these are the topics that I'm not surprised to see the 48 cases under the Americans with Disabilities Act, the ADA, is usually a popular one. The retaliation, as we talked about before, but the uptick in although there's only 5 cases, it's definitely an uptick, right, from 0 to 5 because of the implementation of the Pregnant Workers Fairness Act. And then of course we've got what we think of the typical sexual harassment under Title VII. There were some Title VII alleging sex discrimination. And then there were 16 lawsuits where there were Title VII violations alleged against employers who failed to file adequate EEO-1 reports. So just a reminder if you're subject to that, keep an eye on that. So what does this look like in real life is probably what you're asking. That's a lot of stats and a lot of categories of things that we need to be aware of, but this was an interesting disability discrimination case that the EEOC filed against FedEx. So the EEOC alleged that FedEx had violated the ADA, Disability Act, by ignoring dispatchers' request for accommodations to continue teleworking. In this case, the employee had been working for FedEx, I think, for like 30 years. And basically, she notified them that she had a disability, and she gave details. It was diabetes, asthma, hypertension, chronic kidney disease, and other diabetic-related issues that impacted her ability to walk. So she was requesting remote work. When her office was relocated from Manhattan out to New Jersey, it would have required her to take several trains. So she was hoping to continue to work remotely, which she had been doing for a couple years past. I think the impetus was COVID. And FedEx said, no, we can't accommodate you. We're not going to do that. And so the EEOC went ahead and filed the lawsuit against FedEx because it had denied that accommodation request, which they said for employees with disabilities, it prevented them from returning to work. So we'll have to see how that one played out. But interesting that the EEOC took a pretty strong position on that, especially against a company as big as FedEx. So something to take note of if your employees are submitting requests for accommodation. It's really good to take a pause, take a look, engage in that interactive process, and see what we can do to make it happen, because we've definitely been seeing more cases filed along these lines. So as promised, let's talk a little bit about the Pregnant Workers Fairness Act, the PWFA. We've talked about it because there's been murmurs, and then it finally went into effect June 2023. And just a quick refresh, it prohibits employers from failing to make reasonable accommodations to known limitations of qualified employees unless the accommodation would impose an undue hardship on an entity's business operation. And that undue hardship is underlined because it's a really high standard. The undue hardship standard has to essentially mean that it's crushing to the business. I usually press my clients that if we're going to claim undue hardship, it's not just we missed this person from the team, other people are having to pick up work. We actually need like solid documentation about profits, figures, numbers. What are we going to have to back this up if we have to prove that it was truly an undue hardship? So it also prohibits requiring a qualified employee, meaning that they're qualified to do their job, affected by such a condition, to accept an accommodation other than any reasonable accommodation arrived at through the interactive process. So pretty high standard there. It prohibits denying employment opportunities based on the need of the company to make such reasonable accommodations to a qualified employee. It prohibits requiring employees to take paid or unpaid leave if another reasonable accommodation can be provided. So sometimes it's easiest, not ever truly easy, but sometimes it's easiest to say we can't accommodate you, let's just put you on a paid or unpaid leave. Under the Pregnant Workers Fairness Act, this federal law, we actually, if there's another reasonable accommodation that can be provided, that needs to be implemented. And finally, it prohibits taking adverse action in terms, conditions, or privileges of employment, which has been a conjunctive phrase that's been litigated actually recently. Tying back to what we talked about before, it can look like anything from reduction in wages, schedule changes, responsibility shifts. All of that can be adverse action in terms of conditions or privileges of employment against a qualified employee requesting or using such reasonable accommodations. So really broad protections that we weren't joking around when this law was implemented. So, okay, Lauren, what does that all mean? I give you that prior slide so that you can go back to it because it uses some of the language that the courts are really focusing on, the EEOC is really focusing on. But what are we really talking about here? So the PWFA essentially requires employers to consider employee and applicant, both current employees and potential employees, right? Their accommodation requests related to pregnancy, childbirth, or related medical conditions. So it applies to employers with 15 or more employees. If you have less than 15 employees, you technically don't need to comply with this. And it essentially protects employees and applicants who have known limitations related to pregnancy, childbirth, or related medical conditions. And like I said, why we're talking about it, it's one of the main litigation priorities for the EEOC at the end of 2024, and they've said that it's going to be something that they focus their attention on in 2025 as well. Okay, so since it's going to be top of mind for the EEOC, what are some examples of reasonable accommodations under the Pregnant Workers Fairness Act? This list is not exhaustive. I encourage creativity. When I get on the phone with my clients and we're talking about this, we're talking about all available options specific to the company. But it could look like providing the employee additional, longer, or more flexible breaks to drink water, eat, rest, or use the restroom. Changing food or drink policies to allow for a water bottle or food. This usually comes into context in like the manufacturing setting where there's restrictions, not the office setting or the cubicle setting. Changing equipment, devices, or workstations, such as providing a stool to sit on or a way to do work while standing. Changing a uniform or dress code or providing safety equipment that fits. Changing a work schedule, such as having shorter hours, part-time hours, or later start time. Telework, which is something that the EEOC is also focusing on as a potential accommodation, as we saw in the prior case we talked about. Temporary reassignment to a different position, temporary suspension of one or more essential functions of a job, leave for healthcare appointments, light duty or help with lifting or other manual labor, or even leave to recover from childbirth or other medical conditions related to pregnancy or childbirth. So just some vague general examples, buckets, I guess, of examples, if you will, of potential reasonable accommodations under the PWFA. Okay, so they said they were going to focus on it. The EEOC said it's going to be even more prevalent and top of mind in 2025. So they put their money where their mouth is, and the enforcement began in September of last year with this initial lawsuit that they filed. So the EEOC sued Wabash National Corporation in the U.S. District Court for the Western District of Kentucky. And essentially they're a company, it's a manufacturing company that denied a pregnant employee's request to transfer to a role that didn't require her to lay on her stomach. Instead of transferring her to that different role with the different physical requirements, they said, we're just going to put you on unpaid leave. So again, back to looking at, are there other reasonable accommodations? Can we transfer you to another role? Can we provide you with some sort of device that allows you to position yourself? I can't remember exactly what this employee was doing in the manufacturing setting, but while unpaid leave has historically been an option for accommodation, definitely other avenues need to be explored under this PWFA. And so back to the case, when her leave time expired, the employee actually resigned rather than returning to the same position without modification, and that was at 8 months pregnant. So the EEOC said that was not compliant. It was not compliant under this new law. And the EEOC also pointed out, or is alleging rather, that the company unlawfully required medical documentation to support the employee's request for accommodation. So that was the first case. Then there were two more that were filed in the Northern District of Alabama and the Northern District of Oklahoma. The second one was filed again, the EEOC filed it against Polaris Industries, Inc., which is another manufacturing company who refused to excuse an employee's absences for pregnancy-related medical appointments. required her to work overtime in violation of a doctor's note that she provided during her pregnancy. So essentially, which when you see this in bullet points, you're probably thinking, well, gosh, we would, you know, as an employer, as HR, we would never do this. We would figure this out with employees. But it's as simple as having a policy where employees receive, like this instance, employees were receiving points under the company's no fault attendance policy. And essentially she resigned, she was for it because she was getting the points on that policy, she resigned to avoid termination to protect her pregnancy. So something is, you know, not intentionally discriminating against someone, but taking a look at how those policies can affect workers under the PWFA. It's not always blatant, right? It's not saying, oh, you're pregnant, you can't work for us anymore, we're not going to figure this out. Sometimes it's the EEOC is digging as deep as no fault attendance policies and saying, you know, yes, it applies to employees equally, but how is it affecting pregnant workers under this? So I personally always like to talk to clients about no fault attendance policies. There are always exceptions. There are always situations that we don't know about, right? Sometimes that doctor's note pops up too late and we had just, you know, said, oh, you missed work for 3 days, you're fired. It's dangerous, it's tough, especially in California, to make those assumptions, because what if that doctor's note comes, you know, a day or two later, and then we've just terminated someone's employment in violation of ADA or PWFA or whatever, you know, the alphabet soup of protections that these employees have that we have to stay up to date on. So the third example, the EEOC filed a lawsuit against Urologic Specialists of Oklahoma. They're not a manufacturing company. They decided to, you know, focus on another industry. They were a medical practice that didn't allow a pregnant medical assistant to sit, take breaks, or work part-time at the direction of her treating physician. And instead, they forced her to take unpaid leave. So they probably looked at it, said, we can't accommodate, you know, they probably didn't say we can't accommodate you sitting or taking breaks, but they probably said the position's full-time, we can't let you work part-time, which, you know, may be a reasonable accommodation to put her on unpaid leave, or someone in the situation unpaid leave, but under the PWFA, you really have to take a second look at it and say, can we do this? Are there other options other than unpaid leave? So the employee ultimately refused to return to work, absent a guarantee from her employer that she would be permitted lactation breaks as needed, and she was essentially refired for refusing to return to work. And the EU said, nope, not legal, we're bringing the lawsuit. So we'll see how those play out. And what happens with those. But just a heads up that the EEOC is definitely focusing on these lawsuits under the PWFA. Okay, so what else is the EEOC focusing on? AI. I feel like everyone's focusing on AI, employment, situation related and not. It's, you know, been a whirlwind of available and helpful information, time-saving strategies, but also we've got to make sure that we're looking at potential pitfalls and issues in the workplace with just, you know, knowingly encouraging our employees to use AI or not knowing what they're doing to be efficient, save time, produce work product on ChatGPT or whatever else they're using. If you don't have an AI policy, I would encourage you to check out the DOL's website. They've got some really good guidance on what employers should and should not be doing as far as directing and restricting AI use, but also encouraging it for innovation. So the EEOC outlined instances of where use of AI during the hiring process may trigger Title VII violations. So while we think this is going to be great, this is going to save a bunch of time, there are some pitfalls that we're already seeing here, and the EEOC is definitely going to hold employers' feet to the fire on this. So one example they provided was an employer that was using resume scanners to prioritize applications using certain keywords. And whether it was a virtual assistant or chatbots, they were asking job candidates about their qualifications and rejecting those who didn't meet predefined requirements. There were also video interviews being performed through software that evaluate candidates based on their facial expressions and speech patterns. There was a company using testing software that provides a quote job fit score for applicants or employers regarding their personalities, aptitudes, cognitive skills, or perceived cultural fit based on their performance on a game or a more traditional performance evaluation test. And then there's also employee monitoring software that rates employees on the basis of their keystrokes or other factors. So objectively, fantastic time-saving technology, right? It's really helping employers filter through the loads and loads of job applications to get to those candidates, which is fantastic on, you know, the overall glance. But the EEOC is cautioning employers to make sure that the automation through AI is not creating a potentially discriminatory effect on filtering out these candidates. And they're definitely not letting employers blame AI vendors for the technology. It still falls on the employer to make sure that there aren't discriminatory practices unintentionally happening, right, by these AI selections of these people that they're interviewing in the hiring process. The EEOC actually put out guidance that recommends that employers specifically ask any vendor that you're working with or considering working with to develop or administer an algorithmic decision-making tool, asking them whether steps have been taken to evaluate whether or not that tool may cause an adverse disparate impact. So it's a lot of, you know, if this, then that. If you're using this product, we can't be discriminatory, but what does it look like in practice? So an applicant in this situation was rejected from a position at iTutor Group. They thought something was fishy, and the applicant allegedly submitted their same resume again, but this time they included a younger birth date. And this time the employee secured an interview. So that employee took their complaint to the EEOC, which then proceeded to file a lawsuit against the employer on behalf of more than 200 applicants alleging age and gender discrimination. So the lawsuit alleged that the company illegally screened out women applicants over 55 and men over 60, which again, this probably wasn't a function of the AI saying don't look at resumes of applicants for women over 55 and men over 60. It was just something that was continuing to happen in the screening process. So iTutor denied the allegations and continued to not deny any wrongdoing, despite entering into a voluntary consent decree with the EEOC. This is a little bit updated or outdated, so it wasn't technically last week. And then they paid $365,000 to that group of over 200 rejected applicants, which is tough, right? There's one thing to pay current or former employees if there were wage and hour issues or allegations of harassment, discrimination, but a $365K payout to applicants that you never met, the company never considered is tough, right? Not a fun check for the company to cut. So iTutor, in response to the EEOC lawsuit, agreed to adopt anti-discrimination practices, or policies rather, and conduct trainings to ensure compliance with those EEO laws. So as nice as it is to say, AI, help me screen through these applicants, there's definitely a human aspect that's still needed to make sure, take a look that there's no adverse impact happening, whether intentionally or not. All right, so our little OSHA subsection here, which I think we talk about every year, and workplace safety updates. We're making some predictions around this too. This is, again, all happening as fast as we can keep up with it. But during Trump's first term, under OSHA, he cut inspections to the lowest number in OSHA's history. He declined to issue COVID-specific protections and rescinded key electronic record-keeping requirements. So probably what we expect from his first term will be likely coming through in the second term here. There was, in May of last year, So mid last year, there was what was called the walk around rule inspections. OSHA issued a final rule under its authority to allow chief safety and health officers in charge of an inspection, a worksite inspection, to have discretion to determine whether a third-party representative was reasonably necessary to conduct an effective and thorough inspection. So there was more opportunity to show up to the business, walk around, do in-person inspections without much notice. So we're likely seeing that paused under this new admin. There was actually a pending lawsuit against OSHA in the U.S. District Court from Texas over the legality of the new walk-around rule. So we'll see how this plays out, as well as the proposed heat safety rule. I'm sure you've heard about this, where the proposed standard under OSHA was going to apply to all employers conducting outdoor and indoor work in general industry, construction, maritime, and agricultural sectors, where OSHA has jurisdiction over the workplace. There were heat hazard identification and assessment requirements, preventative measures that were required to be provided to employees, in addition to training and education about heat safety. There was a pretty big record keeping and reporting requirement. So we'll see how this continues to play out under this new admin. OSHA's currently taking comments into publishing the final rule. So if you haven't tuned in to see whether this applies to you and your company yet, make sure that we've got our arms around that heat safety rule under OSHA. While I guess I'll just say these slides are available for you to refer back to. OSHA's current workplace safety environment is aggressive, right? They're putting together these groups. They really went for it in the last couple of years. And while we're expecting the newer OSHA to implement for fewer rules under Trump's second term, it definitely doesn't mean that we should roll anything back yet, or we should not be prepared for these inspections. My firm's website, Fisher Phillips's website, actually has up-to-date OSHA inspection lists of things that are going on. I think it's updated daily, actually. So if you want to take a look at that and see where we're trending, what's happening, to keep an eye towards that, please do. All right, moving right along here. We've got a quick note on the update of non-competes in the Federal Trade Commission. Back in early 2024, the Federal Trade Commission, the FTC, issued a final rule in which they stated that they would promote competition by banning non-competes nationwide. I'm sure you heard of that. Employers had to look at non-compete agreements, non-solicitation clauses, and roll those back. In California, there was actually, I think we talked about it last year, a very specific provision that required employers by Valentine's Day of last year to actively notify their employees if they had signed a non-compete that was now deemed illegal, and tell them in no uncertain terms that that was unenforceable and essentially illegal at this point. So the federal rule was set to go into effect in early September, but in August of last year, the U.S. District Court for Texas has been very busy, the courts in Texas have been very busy, issued an order in a case that said the FTC's ban exceeded its legal authority. There was another Pennsylvania court that just gave a preliminary ruling that sided with the FTC, and a Florida court sided with the changes to the ban. So there's been a lot of court activity about this. The FTC has actually appealed the Texas ruling, and ultimately the Supreme Court will review it. It'll probably be a multi-year process is what we're predicting, but we also think that under this new admin, the Federal Trade Commission will likely drop the legal fight and or repeal the rule entirely. So while it's currently on hold, it's to be seen what will happen with that in the future. So keep your ear to the pulse on non-competes. For now, states control on this, right? So California, the federal law won't trump California, right? If California is more specific, then that's what controls. Okay, so we've got about 15 minutes left. I would love some time for some questions. I think I'm going to, here's the information on the Chevron case from June. I'm gonna actually skip this, and if you want to review these slides, you're more than welcome to. It's a little bit theoretical and not super tangible for you right now. So in our last 15-ish minutes, this case was actually from the Ninth Circuit. It was super interesting. So it's at the federal level, but effective specifically binding on cases on the West, or case law binding states on the West Coast. And it is a reminder to employers to stay in the know and up to date on employee social media activity. So with this case, Lindsay was a former staff psychologist at a federal correctional complex. And she discovered that a lieutenant with whom she worked was responsible for overseeing, this person who was responsible for overseeing the safety of guards, prison staff, and inmates, had created an Instagram page containing multiple posts that were overtly sexist, racist, anti-Semitic, homophobic, and transphobic. And approximately 100 of this employee's coworkers followed the Instagram page, which both explicitly or impliedly referred to the prison staff, and the inmates. And some of the posts even contained derogatory images resembling this particular employee that brought this lawsuit. And the lower court found that the Instagram post relating to the employee that filed the suit occurred entirely outside of the workplace, because the posts were made on a staff member's personal Instagram account, and none of the posts were ever sent to the employee that brought the lawsuit. They weren't displayed in the workplace. They weren't shown to that employee in the workplace or on the clock. And they didn't discuss that person in the workplace without her consent. So the lower court actually found in favor of the prison that this was all fine to proceed. However, the Ninth Circuit at the federal level reversed and said, no, offsite and third-party conduct like this coworker's Instagram page, especially since the coworker was in a position of somewhat power, right? It doesn't have to be the ultimate power, but somewhat power. The conduct can have the effect of altering the working environment in an objectively severe or pervasive manner. So whether the claim was discrimination or retaliation, the Ninth Circuit actually said social media activity done off the clock can be brought back into the workplace and have an effect on the workplace if it's severe or pervasive enough. And in this case, they said that it was. So sometimes it's easy for us to say what happens outside of work stays outside of work. The Ninth Circuit reminded us in last year that moving forward, that's, we can't turn a blind eye to that. And if it's affecting employees at the workplace and affecting their ability to do their job in a safe atmosphere, then it is something that they're going to look at, and they're going to hold employers responsible for it. All right, so quick California update here. Things to keep in mind for, 2023. That's not right. Welcome to 2025. We're 2 years behind. I apologize about that. This information is up to date though, I promise. We've got minimum wage increases in California on the horizon. I think New York may be a little bit higher. Don't quote me on that. I only practice in California. I think they're the highest in the country. So the Department of Finance has announced that the statewide minimum wage for all employers will increase to $16.50, or it did rather, on January 1st. There was actually a prop on the ballot in November that would have increased it even more, but it failed. So interesting voice from business owners in California. 1650 is high. It's definitely having effects on businesses, right? Especially businesses with a lot of minimum wage workers. But remember that there are industry specific and local minimum wages that are higher that will still control. So even though, this is the newest, most up-to-date minimum wage of $16.50 effective on January 1, if you're in industries such as fast food, healthcare, or hotels, for example, there are going to be higher minimum wages for particular employees in those industries. There are actually 40 cities and counties in California that currently have a higher minimum wage, including San Diego, Oakland, Santa Clara, LA, and West Hollywood. Definitely, I mean, there's others. When I work with clients on updating their employee handbooks, we want to pin down where employees are working specifically in California, city by city, for minimum wage requirement reviews and also paid sick leave. A lot of these cities that have higher minimum wage in California also have higher paid sick leave requirements than California as a whole. And good reminder for any state offering those benefits, right? Make sure you're looking at those local minimum wages and local paid sick leave requirements. Okay, so what is actually the impact of the $16.50 state minimum wage in California? And again, this can translate to every state that is having those minimum wage increases. It means that the minimum salary for exempt employees actually rises from $66,560 to $68,640. So that baseline of the exemption is twice minimum wage, right? So when that minimum wage goes up, that threshold for the exemption is also going to go up. So make sure that if we have people categorized as exempt in California, we're paying them at least that twice minimum wage, which is $68,640. It means that the minimum hourly rate for inside sales exemption employees rises from $24 an hour to just over $24 an hour. If you've got employees that are bringing their own tools, that tool rate increases from 32 per hour to 33 per hour. So if you're in construction or construction adjacent industries where you've got those tool requirements, keep that in mind. It has an impact on employees currently making between $16.50 and $17 an hour who may ask for that rate increase. And then if you have employees covered by CBAs or collective bargaining agreements and you're relying on the Labor Code 514 for overtime rules, ensure their pay is being increased to $21.45 per hour. Okay, and I would be remiss if we didn't talk about PAGA reform in California in an update for 2025. So if you don't know what PAGA is, it's like a mini class action that employees are allowed to bring in California. It stands for the Private Attorney General Act, where the California legislature essentially gave the California Labor Commissioner gave employees in California permission to sue on their behalf. So essentially, employees could step into the shoes of the labor commissioner and bring a lawsuit on behalf of all of these other employees without having to meet these normal class action requirements. It's been a very hot topic in California for the past 10-ish years. PAGA lawsuits are filed every day against California employers, and it really came to a head in the last 6 or 7 months. There was a measure on the ballot, and instead of that being set forth, the California legislature actually engaged in months-long negotiations between the business community and labor leaders. And as part of a larger negotiation involving various employment-related propositions on a ballot, they came to an agreement that came into effect where PAGA was actually reformed in June of last year. So there are multiple changes to PAGA that impact how employers are going to prevent and respond to these PAGA claims. Thankfully, there was a penalty modification. So if employers are taking proactive steps either before they receive a PAGA lawsuit or within 60 days after, including updating policies, doing annual auditing, training their employees on wage and hour practices, and disciplining anyone that goes rogue, that is not complying with wage and hour practices, you actually get a severe, like a 70%, up to a 70% penalty reduction in those legal penalties for these cases. So it's definitely something that's worth looking into if you're in California. If you have over 20 to 30 employees, you want to be up to date on this and seeing what you can do to prevent against these claims. And if they are filed, what you can do in response to reduce those penalties. The legislature definitely gave California businesses some ammo here to fight back against these PAGA claims. Okay, this is actually, sorry, I didn't flip to this slide in time, but here's the 4 things that I just talked about: conducting payroll audits, updating employee handbooks and standalone policies and procedures, training managers on wage and hour requirements, and taking corrective action against managers who violate wage and hour policies. And then the very last thing I want to chat with you all about, we didn't talk about 1099 or independent contractors in this update, which is something I usually like to talk about at the federal level. We're pretty stagnant on the classification for a while, and then I think that's actually going to change likely under this new admin too. So keep your ear out for the checklist of how you can make an employee a W-2 versus how you can make them a 1099 on the federal level. I didn't want to just speculate at how that's going to shake out in the next couple of months, but we do expect Trump admin to roll back some of those requirements that were set forth under the Biden administration. But as far as California, there is a new, very specific freelance worker protection law that applies to independent contractors hired to provide professional services, which is obviously a very broad category of employment. It includes marketing, human resources, travel agents, graphic designers, grant writers, fine artists, photographers, videographers, writers, editors, contract creators, barbers, cosmetologists, and more. There were some strong lobbyists, lobbies happening here to be included in this professional services. So there, what seems like pretty basic law, and we usually advise that employers do this when you're engaging with freelance workers or 1099, but now it is actually law in California. The contract for a 1099 independent contractor must be in writing, and it actually needs to be maintained for 4 years, which is an interesting requirement. You generally want to maintain employment records for W-2 employees, both personnel file and pay stubs, for 4 years. But now we actually need to do the same for 1099 workers contracts. And that's the thought behind that is likely if there's a dispute over payment, that we'll have, 1, the agreement will be in writing, and 2, it will be maintained and we can refer back to it for those 4 years if there is a dispute that comes up. So the contract must state the name and address of each party, which is kind of a no-brainer, an itemized list of all services to be provided, which may take some time to sit down and think through what we want them to do, and a date by which the freelancer independent contractor must submit a list of services rendered. We have to pay the freelancer by the contract date, the date specified in the contract, and if it's not specified, it's a 30-day deadline. And I bring this to your attention because with enactment of this new requirement for freelance workers or 1099 workers, of course, there is in California a civil enforcement vehicle. So if we don't comply with these requirements, there are repercussions. If, for example, if the worker requests but is refused a written contract, there's a penalty of $1,000. And if we fail to pay the independent contractor on time, we're actually required to then pay them twice the amount of the unpaid compensation at the time the comp was due. So there can be other damages too, but just to paint the picture, it's important that we jump on these and review our independent contractor status for not only proper classification, but also make sure that we have contracts in place in writing with these specific requirements. And it looks like we're right at the top of the hour. So I'm happy to to respond. I actually wasn't seeing much come through on the chat, but maybe I was not looking at the right place. Michelle, if you want to flip the questions to me, I'm more than happy to respond in email.
Okay, well, and due to the time constraints, I just sent everybody a message. We've got a lot of questions, and obviously we're not going to get to them all, but what I do want everybody to know is that I'll get the questions that you've asked to Lauren, and then we'll email you directly your responses. But let's just take a couple real quick here. I mean, they're all good questions, and it's a lot of information. Let's see here. Somebody wanted to know where they should look for an AI policy.
Oh, good question. Do a quick Google of Department of Labor and AI.
Okay.
They have some parameters. I think there's also, if you go to the Fisher Phillips website, there's some template policies that you can find. If not, shoot me an email. We'll help you find one.
Okay, great. Somebody is asking, with Trump's ever-changing laws, do we anticipate any future litigation cases that would be backdated to current cases once he's out of office, or is there a cap on when employees can file?
It's a really good question. So in general, usually when the law quote changes, it's not the law actually changing, it's an interpretation under the law. So usually there's not a backdate reach or like a cutoff point, but it really depends on what the law is and what's changing. Sometimes they'll say this is retroactive and sometimes they'll say it's not. It's usually my first question when something comes through, specific change. I always say, wait, is this retroactive or is this not? So sorry to give a vague response, but it depends on, it's a case by case basis. We'll just have to ask yourself that question as things come through. Is this retroactive or is this not?
Great. Let's see, let's find another one that won't take too much time. So somebody said that their understanding, and I think they're speaking of the at-will states where employment is at will and you don't need just cause to fire someone. You had mentioned earlier that there were cases where, firing somebody and then it coming back to bite them. So I think they're just looking for examples of what would be a legitimate reason to fire. What would be a I'm not asking it right. What applies to firing an employee? I think they're just trying to figure out what is fireable. That's what I'm thinking. I didn't say that right, but
yeah, it's a good question. And sorry, Michelle, I guess I can't see the questions. I'm only seeing one at a time. So I can definitely review that and get back to them on email. But in general, especially like in California specifically, and in general federally, the employment relationship to defaults to at will, right? So unless, I'm assuming you're asking in situations where we're talking about the EEOC and the retaliation, right? What and how to defend against that. What I usually advise my clients on is if an employee has complained or engaged in any specific activity, first we need to be very careful about whether we terminate them, right? And why. And if we are to terminate them, it obviously has to be for a non-illegal reason.
right.
It has to be for, not only is it at will, we can fire them for any reason, but if they're going to claim retaliation or discrimination, right, then I really encourage my client to think twice, if not 10 times, about what documentation we have to rebut that argument. So if we're going to say, we didn't fire you for retaliation or discrimination, we fired you because of your performance issues, we need documentation to back up those performance issues, right? If we fire them and say they weren't performing, it wasn't working out, then their performance reviews look good, there's no write-ups in their file, there's no documentation support of any of that, it really is hard to defend against those cases.
Okay, great. Well, due to the timing, and Lauren, thank you so much, and for everybody for attending today's webinar presented by Heffernan. We will send you information by email with instructions on how to access a copy of the presentation of our website. And again, as I mentioned, I will get all these questions over to Lauren. I'll try to get them over today, but we will respond to each of you individually, and we appreciate everybody's participation. Thank you, Lauren, for your time and expertise today. We hope that all the attendees found everything in today's webinar to be a valuable use of your time. So be sure to join us on March 11th for our Everything You Need to Know About Your Employee Handbook webinar. Thank you, everybody, and have a great and safe day.
Thank you. Thanks, Michelle.